A vote, a single vote, from a justice whose past rulings, whose ideological alignment, and whose entire public identity made this outcome seem nearly impossible just weeks ago. And yet, here we are, because something just happened that almost nobody saw coming. A Supreme Court justice, one appointed by a Democratic president, celebrated by the left for her progressive views, may have just handed a powerful legal weapon to the side fighting against a dramatic Democratic power grab in Virginia. And the consequences could reshape not just one state, but the entire battle for control of Congress heading into the 2026 midterms. Think about that for a second. How does a single dissenting opinion in a completely separate case, hundreds of miles away, end up influencing a high-stakes redistricting fight in Virginia? How does that even happen? That is the question at the center of this story. And by the end of this, you are not just going to understand what happened in Virginia. You are going to see why Justice Ketanji Brown Jackson's words might have saved fair maps and protected Virginia voters' rights for years to come. This is where we take complex legal and political developments and break them down so you do not just hear about them. You actually understand what is happening and why it matters. Because today's story is one of those moments where everything looks ordinary on the surface. Another case, another ruling, another headline. But underneath that surface, there is a much larger battle unfolding. A battle over control. Control of districts, control of representation, and ultimately, control of the balance of power in Washington itself. My goal today is simple. By the time we are done, you are not just going to understand what Justice Jackson's vote did, you are going to understand why it may have just stopped something much bigger. But to see that clearly, we need to connect every dot, from the backroom strategy in Richmond to the constitutional technicality that nearly allowed a power grab to the national twist nobody predicted. Let's start with the big picture. Right now, Virginia sends 11 members to the United States House of Representatives. That number is fixed by the census, and it represents a genuine balance point. A place where either party can gain or lose ground depending on how things are structured. As things stand, the delegation is split, 6 Democrats and 5 Republicans. It is a genuinely competitive purple state where both parties have a real shot depending on turnout and how the maps are drawn. But after Democrats won big in the 2025 state elections, including electing a new governor, they set their sights on something far more ambitious than holding their 6 seats. Their goal was to flip the map dramatically, potentially creating a 9-2 or even 10-1 Democratic advantage. That is not normal redistricting. That is what many are calling a political heist, using temporary power to lock an advantage for the rest of the decade. Because in modern politics, control does not always come from convincing more voters. Sometimes it comes from deciding how those voters are grouped, which districts they fall into, which votes carry weight, and which ones do not. Now, officially, this was framed as a routine constitutional process, a proposed amendment, a legal pathway, a procedural adjustment. But when you look closer, what was actually being attempted was something far more strategic. Because once those lines are drawn, reversing that advantage becomes incredibly difficult. That is why this was not just another legal dispute. Here is exactly how they tried to pull it off. Virginia voters had previously approved a constitutional amendment creating an independent redistricting commission. The whole point was to take map drawing power away from self-interested politicians and give it to a more neutral body. Democrats, now controlling the legislature and the governor's office, wanted to reverse that. They pushed a new constitutional amendment that would strip power from the independent commission and hand it straight back to the Democrat-controlled state legislature. If they succeeded, they could draw the maps themselves, picking their voters instead of letting voters pick them. But here is where it gets complicated, and where the legal vulnerabilities cracked wide open. Virginia has a very specific, strict process for amending its state constitution. You cannot just rewrite the rules whenever your party wins an election. The Constitution requires the proposed amendment to pass through 2 separate legislative sessions, with a full state election in between them. One legislature votes yes, then the people go to the polls and elect their representatives, then the new legislature has to vote yes again on the exact same language before it goes to voters for final approval. This structure exists for a reason. It forces deliberation. It gives voters a genuine chance to weigh in and choose representatives with full knowledge of what those representatives plan to do. It is a democratic checkpoint designed to prevent hasty, self-serving power grabs. So what actually happened? Let's walk through the timeline carefully, because once you understand how it actually played out, the entire situation starts to look very different. Not just slightly different, fundamentally different. In late 2025, Democrats in the Virginia legislature moved fast. They passed the first resolution for this constitutional amendment in October 2025. Then, after winning bigger majorities, they pushed it through again in January 2026 and got it on the ballot for a special referendum. On paper, it looked like they followed the steps. One vote, an election, another vote. But not so fast. Here's the detail that changes everything. That first vote did not happen before the election cycle began. It happened during it. And that distinction is not a technicality, it is the entire case. Because by the time that first legislative vote took place in October 2025, something else had already started: voting. Virginia's 2025 election did not start on Election Day in November. Like most states today, it had weeks of early voting. Voting began in September 2025. Mail-in ballots went out. Early in-person voting opened. By the time October rolled around, thousands of Virginians had already cast their ballots. People had already made decisions. They had already participated in the democratic process. Some had already completed it. Now stop and think about what that means. If voters are already voting, if ballots are already being filled out and returned, can you still say the election has not started yet, or is it already underway? Because depending on how you answer that one question, you get two completely different legal realities. This is where the arguments split sharply. On one side, the defense of the process relies on a very narrow interpretation. They argue that the election is a single day, Election Day, that specific Tuesday in November, nothing before it counts. Not early voting, not mailed ballots, not the weeks of active participation that happened beforehand. Under that definition, the timeline holds. The first vote happened before the election. The second vote happened after. Sequence complete. Case closed. But here is the problem. That argument requires you to ignore reality. It requires you to look at thousands of voters actively casting ballots and say it does not count. It requires you to treat an ongoing process as if it has not started yet. It is like watching a movie halfway through and insisting it has not begun because the opening scene is already over, and it gets even more serious than that. Because this is not just about timing, it is about information. Evidence presented during the case revealed something that adds another layer entirely. Some voters had already cast their ballots before the legislature even passed its first vote on the amendment. Think about that carefully. Those voters went to the polls or filled out their ballots at home and made decisions about who should represent them, without knowing that those same representatives were about to vote on stripping power from the Independent Redistricting Commission. They did not have the full picture. They could not factor it in. They could not respond. And that cuts directly against the purpose of the entire process. Because the whole reason for requiring an election between legislative votes is to give voters a chance to weigh in, to make informed choices, to hold their representatives accountable before a structural change takes effect. But if the vote happens after people have already started voting, that opportunity disappears. It is gone. And what you are left with is not a safeguard, it is a loophole. A state trial judge agreed and struck the entire process down. Not partially flawed, not in need of correction, invalid from the start. The case then moved to the Virginia Supreme Court, where oral arguments were held and a final ruling came down. But here is where the national twist enters the story, the part almost nobody saw coming. While this Virginia fight was unfolding, something important happened at the United States Supreme Court in a completely separate case involving Louisiana and redistricting under the Voting Rights Act. The issue involved whether courts could allow changes to election rules and maps after ballots had already been sent out and some votes had already been cast. Different facts, different state, different legal context. But the same underlying question at its core: when is an election actually considered to be in progress? And during that case, Justice Ketanji Brown Jackson took a position that cut straight to the heart of that question. She argued forcefully that once ballots are sent out and voters begin casting them and returning them, the election is not some future event waiting to happen. It is already happening. It is already currently in motion. She laid out a clear logical framework. Elections today are extended processes. When voting has begun, legal changes that affect the rules midstream create serious problems of fairness and voter confusion. Her reasoning rejected entirely the idea that you can pretend weeks of actual voting simply did not happen for procedural purposes. Now apply that logic directly to Virginia. Early voting opened in September 2025. Ballots went out. Over 1 million votes were cast before the legislature's first vote in October. If an election begins when voting begins, as Justice Jackson powerfully argued, then the Virginia legislature voted during the election, not before it. The constitutional separation was never properly established. The entire sequence was broken from the very start. Now pause and think about the irony here. A dissenting opinion from the United States Supreme Court is not binding on Virginia's state court. Everyone understands that. But persuasive authority is real. Well-reasoned arguments, especially from sitting Supreme Court justices, do not just disappear. They travel, they influence, they shape how future courts think about similar questions, and in this case, the overlap between what Jackson wrote and what Virginia's courts were being asked to decide was impossible to ignore. Same issue, same logic, same conclusion. And that is the part that should make you stop and think. Because this was not a majority opinion. It was a dissent, written by a justice appointed by President Biden, a justice the political left holds up as a symbol of progressive jurisprudence. And yet her words, written for one purpose in one case, became one of the most powerful pieces of persuasive authority for stopping a Democratic power grab in an entirely different state. That is not spin. That is not partisan framing. That is how the law actually works. Ideas and reasoning travel beyond their original case. Truth does not belong to one side. In the end, the Virginia Supreme Court issued its ruling. In a decision that surprised many national observers, they sided with the broader and more realistic definition of an election. They held that the constitutional amendment process failed to meet the required standards because the first legislative vote occurred after voting had already begun. The referendum was declared invalid. The attempted power grab to eliminate the Independent Redistricting Commission was stopped cold. This outcome is massive, and not just for Virginia. The Independent Redistricting Commission remains in place. The current maps, the ones that produced a competitive 6-5 split, will govern the 2026 elections. Democrats cannot simply redraw the entire congressional map to create a lopsided advantage through procedural trickery. Virginia remains a real battleground where both parties must compete for every vote instead of hiding behind manipulated district lines. But step back and look at the bigger picture, because what is happening here reflects something much larger unfolding across the country. Virginia holds a uniquely important position in American politics. With 11 seats in the House of Representatives, even a slight adjustment in how districts are drawn can tilt the national balance of power. And in a closely divided Congress, that tilt can determine everything. Which party controls legislation, which agenda moves forward, which policies become law. Before this ruling, Democrats were positioning themselves to potentially flip a competitive 6-5 delegation into a 9-2 or 10-1 advantage. That kind of shift does not just change Virginia, it changes the math for the entire country. In a House often decided by just a handful of seats, rigging the map in one large purple state could hand one party a structural advantage that no amount of voter turnout or persuasion could easily overcome. By striking down this rushed amendment, the Virginia Supreme Court protected the safeguard the founders put there for exactly this reason. They understood that the party in power would always be tempted to tilt the field in their favor. The double pass requirement with a full intervening election was designed as a deliberate speed bump, a defense against sudden self-serving changes made by whoever happens to control the gavel today. And there is a deeper lesson sitting underneath all of this. This case was never really just about redistricting. It was about whether the written rules of constitutional democracy still have teeth. When one side has the votes and the motivation to push through changes quickly, do the guardrails actually work? Or can they be gamed with clever timing and narrow definitions? The Virginia Supreme Court answered loudly, the rules still matter. They are not optional. They apply equally no matter which party is in power. And that principle, equal application of the law and constitutional procedure, is what truly protects rights not just today, but going forward. Because once you allow one party to bypass the rules for short-term gain, you open the door for the other side to do the same when power flips. The only real protection is strict adherence to the process, even when it is inconvenient. That consistency is what gives citizens confidence that the system is not completely controlled by whoever holds power at any given moment. This ruling also sends a powerful warning to other states watching closely. Procedural shortcuts will be scrutinized. In an era of expanded early voting and mail-in ballots, courts are increasingly unwilling to pretend that weeks of actual voting do not count as part of the official election. That shift toward legal realism strengthens democratic integrity. It closes the gap between how elections used to work on paper and how they actually function today. Because here's the reality. Elections are changing. The way people vote is changing. Early voting, mail-in ballots, extended voting periods, these are now central parts of the process. They are not exceptions anymore. They are the norm. But in many cases, the legal framework has not fully caught up. Some rules still treat elections as if they happen on a single day, while the reality is that voting now stretches across weeks, and that gap, that disconnect between law and reality, creates opportunities to interpret timing in ways that were never intended. What this case forces courts to confront is a direct question. Do we define elections based on how they used to work or based on how they actually work today? Because that choice does not just affect Virginia, it sets a precedent, one that other states will look to, one that future courts will rely on, one that will shape how election laws are interpreted for years to come, and bring it all back to where this story began. Justice Ketanji Brown Jackson did not set out to influence a redistricting fight in Virginia. She was writing about a different case in a different state with different facts, but by telling the truth about when modern elections actually begin, by putting into clear and honest words what every voter already understands instinctively, she provided a tool that helped preserve fair play in a state she was not even thinking about. That is what makes this story so extraordinary. A justice whose opinions are usually celebrated by the left ended up supplying one of the strongest arguments against a left-leaning power play. It proves that good legal reasoning transcends partisan lines. When a judge correctly describes how elections work in practice, that truth becomes available to everyone regardless of which side tries to use it. The Independent Redistricting Commission stays in place. Both parties must compete on fair ground in 2026. The rushed attempt to lock in a decade of advantage has been stopped. And the principle that voters, not politicians, hold the ultimate power over how representation is structured has been reaffirmed. This moment reminds us that the Constitution is not a dead letter. Its protections can still function when courts take them seriously. In Virginia, those protections just saved competitive elections, preserved an independent commission, and defended the idea that the rules of democracy apply equally, even when applying them equally is politically inconvenient for the side that wrote them. Keep your eyes on Virginia and the similar fights brewing in other states, because the battle over fair maps and fair rules is far from finished. But today, at least in one state, the guardrails held, the rules pushed back, and the voters won.